rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is a time set for oral argument in the case of Kevin Miller versus the Industrial Commission, Sun Devil Fire Equipment, and Amateur Insurance. Each party will have 20 minutes within which to make their arguments this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of the time in that regard, Mr. Kurth. We have been through the record from both ICA proceedings. We've read the briefs. We, in fact, conferenced the case this morning. So we're pretty familiar with the underlying facts and the issue in front of us today. As you approach the podium, please identify yourself and your client. We are recording these proceedings both by audio and video. And if you really want to check out the video in a few weeks, you can go to YouTube for that regard. With that, we're ready to proceed. Mr. Kurth.
Good morning, Your Honors, Mr. Baker. My name's Dennis Kurth. I'm with the law firm of Snow, Carpio, and Weekly, and I represent the petitioner, Kevin Miller. I want to thank you, first of all, for granting oral argument. I'm sure Mr. Baker appreciates it as much as I do. It's always a great honor to get up here. I know I've been in this business for a very, very long time and had a lot of oral arguments, but it's always a very formal, wobbly knee experience when you get into this atmosphere here. So I do appreciate the opportunity. This case today, this Kevin Miller case, is a very important case concerning res judicata and the finality of Industrial Commission awards. But it also concerns fairness, consistency, and helping injured workers get the medical treatment they need to recover from their injuries and get back to work. Preclusion seems to have become a problem that's endemic to the workers' compensation industry as opposed to the regular civil system, because in our system, and I know, Judge Winthrop, you've had experience in our system, and Judge Norris, you've probably seen a lot of workers' compensation cases too, but you know that our cases are not decided at one time after one trial. We often have, in serious injury cases, a series of litigation. We may go through litigation over compensability. The carrier might deny the claim because of a scope of employment issue. And then after the case gets going and that issue is resolved, we often come back with litigation over what we call continuing benefits, or whether a person's condition is stationary. And then later there might be litigation over whether they're entitled to a permanent loss of earning capacity award. So some of these cases have a life of their own and they go on for years and years and years. And it's kind of strange that there would be preclusion problems where you're dealing with a system in which the prior awards that we're talking about in the finality are all from the same system, but we do obviously get these kind of problems.
So
and
your point, Mr. Kurth, is that in the comp system there are sequential issues that are resolved. One of the questions I had to do with initially with preclusion, and I mean that's an affirmative defense, isn't it? Would you agree?
I'm not sure it's an affirmative defense. I think it's certainly a matter of law that has to be applied by the ALJ. I'm not aware of any case that says it's an affirmative defense. I
was just curious that the issue wasn't raised here until the request for review stage. Wouldn't it make sense that it be raised either when the medical report of Dr. Doring was submitted or he started to testify?
You know, Judge, you're absolutely right. And I take blame for not having raised that more emphatically, you're absolutely right. But it was raised directly in the request for review. But the point I was trying to make was when these cases come back for further litigation, the Industrial Commission Chief ALJ doesn't assign them to the same judge that did the earlier litigation. They try to give you a new judge with a different perspective. And then when you do get a brand new judge at the Industrial Commission, who's not used to applying preclusion or seeing it in this type of context, then that's where these problems are arising. And sometimes, to be honest with you, sometimes it's difficult when you get involved in these cases to pick out these preclusion issues. We're all dealing with a lot of cases and hearings every day, and yes, sometimes you miss the opportunity to bring that to the judge's attention. And at the Industrial Commission, we often don't engage in oral arguments or final arguments or things like that. But I mean, I take the blame for not bringing that issue and making it more clearer to the new ALJ.
Your point, your position is that raising it at the request for review stage is sufficient?
Yes, it is my position that raising it at the request for the judge still had an opportunity to address it on the request for review. But this case was typical of an industrial case that goes through a couple different series of litigation. We go through a hearing with Judge Retzer, several hearings, 2013. He resolves a medical conflict in favor of Dr. Weiner against Dr. Bagan. Bagan says arachnoiditis is the problem. No surgery will help it. Weiner says it's not arachnoiditis. It's L5S1 stenosis, facet arthropathy, and surgery might resolve it. Judge Retzer resolves that conflict in favor of Dr. Weiner. And he actually mentions in his award that Dr. Weiner says that the treatment necessary will be repeat MRI, epidural injections, possibly extension of the L5 fusion. So it isn't even, I mean, as soon as Dr. Weiner then asks for authority to do an epidural injection, the carrier denies it and sets up the IME with Dr. Doring, and the case proceeds to litigation again.
Counsel, so you're saying not only is it consistent with, but Weiner's, what triggers the preclusion problem is something that was clearly anticipated within the prior order, not just an extension of what Weiner had asserted. Does that make sense to you?
Well, what triggers...
It's actually almost overlapping in the sense that the ALJ says, Weiner says it's going to require this. As soon as Weiner begins to do that thing, then you get the objection.
Right. So basically, then you get the second IME, but the second IME says the same thing as the first one, Dr. Bagan. And fortunately, Dr. Doring had actually written Mr. Baker a letter in which he said, I agree with Dr. Bagan, his arachnoiditis-induced pain, blah, 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 radiculopathy is not amenable to surgery. So he made it pretty clear himself that he agreed with Dr. Bagan. Now, the administrative law judge, if this case had gone to hearing the second time and the doctor was the same, they had an IME again with Dr. Bagan, they couldn't possibly present that to the Industrial Commission and ask the judge to rule in their favor. That's a second bite of the apple. The judge decided in that decision by accepting Dr. Weiner that the injury was not arachnoiditis, but a organic problem at the L5S1 level, and that required particular treatment. So how can you win the case at the Industrial Commission when your doctor's testimony is selected as the basis for the award, and the treatment is described by the judge in the award, and then as soon as the doctor wants authority to do the first epidural injection, the carrier gets a second IME who agrees with the first one, case goes to hearing again, and then the second judge just addresses it as a conflict in the medical evidence that can be resolved. And that's what's not fair. When preclusion is not applied where it should be applied, it works to the great detriment of the claimant. I mean, look at my client, a young guy, barely 31 years old, was doing great on this job despite a very serious prior injury. He's awarded treatment by Judge Retzer in December of 2013. It's immediately held up in March, April of 2014, and then the second IME. He's now been 2 over 2 years without any treatment, without a chance to get possibly the surgery that Dr. Weiner was thinking about, and get himself a chance to recover and get back to work. This is working to the great detriment of these workers. Preclusion really needs to be looked at carefully. And, Judge Winthrop, the problem that you pointed out, why didn't I make it clearer to Judge Radke? You're absolutely right. That was my fault. But that shows you sometimes how difficult it is to appreciate these kind of issues when you're doing a whole lot of volume of litigation on these cases.
Yeah, could you look at Doring's testimony and say that what he's really saying is, all right, I accept that the industrial accident of 2012 exacerbated or aggravated his pre-existing injuries from 1999, but to the extent he needs any further evaluation or treatment of that, it is not active medical treatment. It's in the nature of supportive care. So it's not really a preclusive issue. I'm willing to accept this idea that these conditions were aggravated, but I don't think he needs active medical treatment for them.
Well, actually, fortunately, because of that letter that Dr. Doring wrote to Mr. Baker, he made it perfectly clear that that's not what he was saying. He was not agreeing with Dr. Weiner that there had been an aggravation of the prior fusion at L5S1. He made it pretty clear in that last sentence of his letter that his arachnoiditis-induced radiculopathy will not be improved by surgery or injections. So I think that differentiates the situation, and Doring was pretty clear. Even Judge Radke in her award, she wrote, Dr. Doring testified that the claimant has arachnoiditis.
What role did the lumbar strain have to do with aggravating that? Was that a triggering related event? I mean, I didn't.
Well, that's what Dr. Doring said. There was a lumbar sprain that aggravated the arachnoiditis in the client. However, the claimant had no problems with his spine, despite alleged arachnoiditis, for the years that he worked for this company after he moved out to Arizona from the accident and the treatment that he had in Michigan. So, you can. As I know Mr. Baker did in his brief, did a great job of explaining all of Dr. Doring's reasons for saying that surgery wasn't necessary. But what it boils down to is the diagnosis. He and Dr. Bagan believed it was arachnoiditis. You can't do surgery to correct arachnoiditis. So when the judge picked Dr. Weiner, then, that's a whole different direction that the case went in. The claim then became the aggravation of the organic problem with the fusion at L5S1, and the client was entitled to get that treatment that Judge Retzer awarded. This is, as I said in my brief, it makes it a little bit more clearer than the Perry case. Because in Perry, there were several years between the two rounds of litigation that ended up in the Court of Appeals. Here, as soon as the claimant went back to get treatment from Dr. Weiner, it was cut off, and a second IME was set up.
Even if we end up agreeing with you, Mr. Kurth, I mean, this is just an interim stage leading into the next battle, which is if Dr. Weiner does his further investigation and injections bringing no relief, he'll be recommending surgery.
Yes.
And the carrier will say, no, we don't agree.
But, and Judge, sure, they can, but can they then stop his treatment with an opinion like Dr. Doring that says no surgery is needed, but because he agreed with Dr. Bagan, whose diagnosis and testimony was rejected? So no, under that scenario, even though Mr. Baker argues that, well, surgery was not decided in that first award, that's true, but you can't come now and relitigate the issue of whether it was arachnoiditis or an L5S1 problem. That's the essence of what Judge Retzer decided. That's what he decided. And that's why it's not like Dr. Doring said, yes, his L5 S1 prior fusion was aggravated, but I disagree that surgery is necessary. By the time this case went to the second IME, Dr. Weiner was not actually recommending surgery. He was just simply trying to get authority to do an epidural to see if...
So what you're saying is that Doring should never have been allowed to talk about how the claimant's physical findings were inconsistent with this radiculopathy on the right.
Essentially, if all he was going to do was mimic Dr. Bagan, whose testimony was rejected, that's right.
But was that the purpose of the second IME? Was to simply raise from a new doctor an old issue and get around the issue of preclusion? We have a new IME you need to look at?
Well, it's hard to say what the purpose was other than Dr. Weiner was requesting authority to do an L5S1 epidural, as Judge Retzer awarded. The carrier decided to have an IME. What was in their minds at the time was probably to avoid having to pay for surgery eventually.
On page 4 of your opening brief, you say Judge Retzer awarded petitioner temporary compensation and medical treatment as set forth by Dr. Weiner until his condition becomes medically stationary. And then you say, as soon as he started the medical treatment, then we get the objection and we're back to it again.
Right.
So there wasn't a case where there was a break. As I read your position, you're saying there wasn't a break between what Judge Retzer said that Weiner had the authority to proceed with and what Doring then came in and said, oh, no, this is all different. They literally overlap with Judge Retzer's decision being implemented, and when it was implemented, then there was an objection to it being implemented effectively.
Right. And Judge, that's much different than the last reported opinion on preclusion from the Court of Appeals, the Aguayo case. In that case, there was a time passage where the claimant did get the medical treatment, and then much later the issue became whether there was a permanent impairment. Here, the guy didn't even get the treatment. This is much more closely related to the Franks versus USF&G case in '85 than anything else. You set up an IME, the judge issues an award saying treatment is indicated, carrier immediately sets up an IME and denies it. Judge writes an emphatic award saying you got to give him the treatment, carrier immediately sets up an IME. So what I'm saying is, in fairness, you've got to give the claimant a chance to get the treatment that Judge Retzer awarded him. Your Honors, we urgently in the workers' comp community, we urgently need your guidance on these preclusion issues. And there's preclusion cases up here. There's amicus briefs around. There's preclusion cases up here. One at least has recently been disposed of in a memo decision, which I have reason to believe they might ask the court to publish. But this is a better case. In the Aguayo case, preclusion was found not applicable. The last opinion was Perry, 1987 or so, in which the court explained where preclusion was applicable. We could really use an opinion where the court explains when preclusion is applicable, because we really need this type of guidance. We should not be having these kind of preclusion problems at the Industrial Commission. And if you don't mind, I would like to save the rest of my time.
Thank you. All right. Mr. Baker.
Thank you. Steve Baker for Sun Devil Equipment and Fire and Amerisure. I'm from Jardine Baker Hickman Houston. Good to see you all. First of all, let me dispel a theme here that the applicant did not get the care that he was entitled to. When you look at Judge Retzer's decision, he notes that Dr. Weiner was of the opinion the applicant was not stationary and needed further treatment in the form of a repeat MRI, which by the time Dr. Weiner testified had been completed together with AP, lateral inflection x-rays, together with a repeat CT scan, and the MRI was actually with and without gadolinium. The reason the applicant never had physical therapy was because Dr. Weiner never ordered it. The reason Dr. Weiner never ordered it was by the time Dr. Weiner testified, he noted that the SI joint was no longer the problem. The applicant did have the repeat SI joint injections that he requested. So the idea that he did not get the care recommended by Judge Retzer, or found to be necessary by Judge Retzer, is not true. He got the treatment.
For the SI joint.
Correct.
Right.
But when you look at this award, we were not ordered to provide the epidurals for L5S1. Possible extension of the applicant's fusion to include L5S1. And that was only a possibility. So when we initially litigated this case, what was the focus? When everyone testified in 2013, it was the SI joint. And Dr. Weiner was of the opinion that that was the pain generator. Dr. Bagan disagreed, and their disagreement was kind of a philosophical disagreement. Mm-hmm. Dr. Bagan didn't believe that the SI joint, because it can't move except in childbirth, could possibly be the explanation for the guy's complaints.
But didn't, I mean,
So
Weiner also, I mean, I understand a focus of Weiner's investigation and working plan was with respect to the SI joint, but there was another focus as well, which was this foraminal narrowing, the facet on the left, producing in his mind symptoms at L5. So I think there's a way to read Retzer's award to authorize further investigation and treatment as it related to the S5 or the L5.
And by the time Dr. Weiner had testified in the most recent round of cases,
I know it's his focus changed.
right, but the individual, Mr. Miller, had undergone 6 epidurals without any significant benefit. I mean, from the time this claim was closed in January of 2013 until it was reclosed in October, effective July of 2014, he'd undergone, I believe Dr. Doring counted them up in his testimony. He said there were 6 epidurals without any significant benefit. I mean, how many times are you going to do an epidural without benefit before you realize that, well, then these aren't working? So then
The way I read Dr. Weiner's testimony was he didn't agree with Doring as to the efficacy of the therapy and whether the investigation was completed or not. In his mind, he had not yet reached the point where he was going to say, this therapy is not successful, and so now I have an opinion that he needs to have surgery. That's coming, perhaps.
But in Retzer's decision, he says he doesn't even address the need for the epidurals, and there was never an opinion to a reasonable degree of medical probability that he had to have the epidurals. So then the focus became at the next round, is this gentleman a surgical candidate at L5S1? And that had not been litigated to any extent in the first round. We never discussed whether or not he needed surgery to a reasonable degree of medical probability. And one of the problems we ran into was that the affirmative defense was never raised in front of the judge at the hearing level. There was no objection made to Dr. Doring testifying on the basis of res judicata. Claim preclusion was not raised as an affirmative defense in front of Judge Ratke. It wasn't raised until after all the testimony was taken.
Of course, in all fairness, when Mr. Kurth raised this at the request for review level, you didn't say, hey, he's precluded, and you didn't. In your briefing to this court, you have not argued that to the extent that's an affirmative defense, it's been waived.
But it has been. I mean, you're right, but it has been waived, and the problem we've run into is that because it wasn't brought up in front of Judge Radke, how was she going to rule on it before all the evidence was taken? So it's not fair to her to raise it at this point in time and overturn her decision. But most importantly, it doesn't apply in this case because Judge Doring accepted that there was an aggravation of the underlying condition.
I'm sorry, who accepted?
Dr. Doring.
Dr. Doring, all right.
He accepted the testimony that there was an aggravation of the underlying condition. And if you carefully read Dr. Weiner's testimony on pages 17 and 18 of the 2013 transcript, he notes that the individual does suffer from arachnoiditis. He doesn't refer to it as arachnoiditis, but he notes that there was a prior damage to the nerves and the automobile accident reactivated the radiculopathy. Well, that's a different way of saying arachnoiditis. And then most recently, in one of his notes, he specifically notes that the patient's condition is being contributed to by arachnoiditis. His note of 1/7/2005, 1/7/2015, certainly post-laminectomy syndrome and possibly some arachnoiditis from its extensive prior surgery is a factor. So everyone acknowledged that there was, to some extent, some arachnoiditis going on here. He'd had an aggravation of his underlying condition. So now the question becomes, the SI joints no longer the issue. Now we're focusing on L5-S1. No decision was made to a reasonable degree of probability what treatment was needed for that. Are we going to give more epidurals that aren't efficacious? Are we going to proceed to surgery where the disc height is normal? There is no instability. If the facet joints are symptomatic, you still aren't going to do an extension of the fusion because there's no instability. Even Dr. Weiner's own diagnostic studies, the AP films that were done after Judge Retzer's decision, showed no movement that would justify surgery. And he conceded in 2013 that the MRIs didn't demonstrate any nerve root compression. So what are you going to extend the fusion to do if there's no instability and no nerve root compression? And so that's why Judge Radke reached the decision she did. It didn't make sense to authorize surgery at this point. It may be necessary in the future, and they can reopen for that. But at this point in time, given what we're seeing on the most recent MRIs that were ordered by Judge Retzer, we're not seeing nerve root compression, we're not seeing instability. So she came to the conclusion that, well, then why are we going down this line? We're going to authorize more SI joint injections. I don't recall what else she awarded in her supportive care. But there's nothing to do actively for this gentleman at this point in time. And if more investigation is needed, Dr. Weiner can do the more investigation, and then the applicant can file a petition to reopen. He's not precluded from doing that.
And so in your view, a petition for reopen would have to be based on evidence of instability or changes in the disc?
Correct. Correct. Because that's the indication for surgery.
Even though in the claimant's mind and his treating spinal surgeon's mind, the symptoms have been consistent in the years prior?
Well, but we have these kind of disagreements all the time. And that specific argument wasn't addressed at either level, at the level in 2013. It wasn't. No decision was made as to whether or not he was going to need surgery. And even now, Dr. Weiner, when you look at his testimony, he hasn't said that the gentleman needs surgery to a reasonable degree of probability.
Well, that's in part the way I read it. He's not ready to make that determination because he doesn't believe that his investigation is completed.
Yeah, but I don't see what additional epidurals are going to do on an active care basis. They're supportive care. They can always file a request for investigation for more epidurals if they want to. A judge could award more epidurals at this point in time. If they filed a request for investigation, supportive care is never finalized, except when it's litigated, and supportive care wasn't specifically litigated in this case. So if there's more investigation to do, they file a request for investigation for more supportive care. We take the opinions of the doctors if they disagree, and if he's awarded more epidurals, he gets more epidurals. I mean, that's the beauty of this system. I know.
That's one perspective, I guess.
Well, I mean, but think about it. You know, Judge Weiner was adamant that we were dealing with an SI joint problem when we first litigated this one, and he was adamant that this gentleman was probably going to need a fusion. But the applicant got better, and so the system can adjust to that and say, okay, that's better. Now, is he a surgical candidate? Yes or no? Probably not at this point in time. But that's why this is a good system, because people get better, people get worse, and the system adapts to that as opposed to reaching a final judgment that says, okay, you're better, here's your money, you're on your own now. This system says, no, you stay in the system. If you get worse, we'll take care of you. If we get better, then we'll move in a different direction. I mean, there's still issues to litigate in this case concerning loss of earning capacity. Does he have a monthly entitlement? There's going to be further issues regarding whether or not he needs more or less supportive care. But Dr. Doring, I don't think, violated anything in the prior award. The gentleman got the care that Judge Retzer recommended. The applicant got better. So we shifted focus now, what care are we going to provide for L4-5? That was never definitively decided in the original decision. And Dr. Dorian accepted the proposition that there was an aggravation of the pre-existing condition. Both Dr. Dorian and Dr. Weiner agreed there was some arachnoiditis at play here. They both agreed that there was facet issues. They disagreed as to whether or not those facet issues required surgery. Dr. Dorian thought that the facets were solid and didn't require surgery. Dr. Weiner didn't really say whether or not he wanted to do surgery because of the facets. He was concerned about foraminal stenosis, but when Dr. Dorian looked at it, he didn't think there was significant enough foraminal stenosis to do surgery. And Dr. Weiner in 2013 specifically testified that there didn't seem to be sufficient nerve root impingement at that time to do surgery. So I'm not convinced Dr. Weiner really was recommending surgery even presently. And as far as additional investigation goes, the best investigation is to see how the gentleman does over time. Any other questions?
I guess not.
Okay. Well, thank you very much. I appreciate your time, giving us the opportunity to present our cases.
Thank you, Mr. Becker.
Your Honors, this is a good workers' compensation system. You know, everybody likes it. It does work effectively. Judge Radke is a brand new judge, but she's a very thoughtful, smart woman, and she's going to be a very good judge. It's just difficult to pick these preclusion issues out, and it was for her on this case, and it was my fault for not making it easier for her to do that. I did try to do that on the request for review, and she ignored it. But she will be a good judge, and the system will work. But, you know, this matter of medical opinion, you know, this case just illustrates the fact about medical opinion in workers' compensation cases. Two very highly regarded orthopedic spinal surgeons have two completely different ideas about what the cause of the problem is and what the treatment is. That's unfortunately very characteristic of the system. The question is, what is the integrity of Judge Retzer's award? He resolved the conflict in the medical evidence. He gave the claimant the treatment that Dr. Weiner was recommending, and the claimant didn't get it. He didn't get it after Judge Retzer's award. He had a couple epidurals before that. He had a couple sacroiliac joint injections before that. And by the time of the second litigation, Dr. Weiner had decided that the SI joint problem had calmed down, and it was now just that problem at the L5-S1 level.
Well, Mr. Baker's telling us that the claimant had 5 or 6 epidurals, at least implied that they occurred at the lumbar level.
There were epidurals. I can't remember if it was 5 or 6 or 4 or 3 or 2. There were at least a couple, but that was before the litigation in front of that Judge Retzer resolved. Judge Retzer took that into account. Dr. Bagan testified that epidurals won't do any good, and part of the basis for his testimony was maybe that the applicant didn't get enough relief from epidurals in the past. Dr. Weiner wasn't ready to do surgery. He was just asking for authority to do an L5-S1 epidural after Judge Retzer's award. He wasn't allowed to do it.
I just want to make sure I understand here, Mr. Kurtz. So your view of the record is that after Dr. Weiner had provided some therapy for the S1 problem and had seen positive results, he turned his attention to the L5-S1 level and started to do some investigation and projected therapy for that, and that's where he was blocked.
That's where he was blocked. Exactly. That's exactly where he was blocked.
Where did Retzer leave the issue of surgery, fusion of the L5?
He left it where he had to leave it. All he could do was resolve that conflict between Dr. Bagan and Dr. Weiner, because there were two very vastly different competing theories of what the injury was. So he resolved that. And by resolving it in favor of Weiner, he opened up the possibility that Dr. Weiner, after applying more epidurals and an MRI or whatever else he wanted to do, would conclude that surgery was necessary.
The anticipation was, although it's not currently prescribed, that fusion to run that whole block of fused joints to the L5 was something that was anticipated, planned. It would be within Weiner's purview to do that once he decided that that was the next indicated step, correct?
That's correct. Absolutely.
All right. Thank you both.
Thank you, Judge.
For taking the time to visit with us this morning. We appreciate your input. We're going to take this matter under advisement, and we'll issue a written decision in due course. With that, we are adjourned. Thank you.